Welcome, everybody, to the Payments Strategy Show. I'm Joshua Silver, founder and CEO of Rainforest. We help software platforms embed payment processing into their core product to grow revenue and improve customer retention. I'm here today with two fantastic guests, Ed Marshall and Theresa Kananen. Ed and Theresa are both payment litigators specializing in the payments industry. They both have over a decade of experience and are co-chairs of the Payment Systems and FinTech Industry Group at a leading firm, Arnold Golden Gregory, AGG. I've known them both for many years, and they bring a really unique viewpoint to the payments industry, combining both commercial expertise and a deep knowledge of payments. And they have graciously agreed to answer some of the most common questions that we hear about the legal side of merchant underwriting, regulatory compliance, and litigation. Ed and Theresa, thank you so much for joining me here on the show.
Thanks for having us.
Yeah, pleasure to be here.
So, of all the things you can do with a law degree, what really sparked your interest in payments?
Dumb luck.
Yeah. It's like one fascinating bankruptcy case that happened in 2011 that was an amalgamation of so many different threads of payment. We were representing a processor and a merchant had a data breach, and we were fighting over the reserve funds, which were desperately needed to address the data breach, and sort of defending by proxy Visa's long discontinued ad card program. And so we dove into the deep end of the payments pool below those many years ago and never really looked back.
Yeah, and I think in our naivete was so deep, in retrospect at the time. I remember asking our client, who was a big processor, can you please give me your contract with Visa? Which would make sense as a lawyer to ask that question. But if you know payments, it was, she kind of chuckled, my in-house lawyer chuckled at me and said, well, Ed, we don't really have a contract with Visa. This is how it works. And so we got a crash course in education. But I think three things about the payments industry are attractive, at least for me, and I think for Theresa as well. Number one, it's such a counterintuitive structure. It's not unlike anything else you encounter as a lawyer. So it's interesting. It's inherently interesting. Number two is you have complex and competing rule sets. It was almost like an LSAT question for those who are familiar with that abomination of a test. But you have card brand rules, you have state law, you have federal rules, you have contracts, as you have to figure out how all those things work together to produce a legal outcome. And then you have so many players in the space, with the merchant and the platform and the payments provider and the gateway and the card brand and the sponsor bank. And whenever you have that many people, when there's a problem, there's going to be friction and there's going to be a little bit of hot potato tossing to try to figure out whose responsibility it is. And as lawyers, litigators especially, that's what we love. That's what we live for is having that fight and making sure our clients aren't the ones holding that hot potato.
It's amazing. We've done dozens of these now. We always ask how people got into payments, and everybody without fail says it was something around dumb luck. And so I'm glad to know that trend continues even on the legal side.
Oh, for sure.
It's kind of interesting. Why do you think payments and law interact so often? And what about embedded payments specifically makes the legal and regulatory conversations, just really unavoidable?
So Theresa and I talked about this in advance, and maybe I'll start and then hand it over to Theresa to finish. But I think number one is it's not just the law applicable to you. It's the law applicable to everyone you're servicing now touches you. So that if you're supporting a merchant engaged in illegal activity or, regulatory sensitive activity, that becomes your exposure as well. And that's unlike, our healthcare colleagues, you focus on a medical practice. You're all focused on the medical side. In merge payments, it's everything. And then I think every innovation requires you to balance the idea, the permissibility of what you're trying to accomplish. Like you want to charge a little bit more for accepting a card. Okay. That's called a surcharge. Is it compliant with card brand rules? Is it compliant with state law? Depending on certain verticals, is it compliant with federal law? And it's just never an easy answer. But Theresa, I know you have more to add.
Yeah. The other thing is that payments is fundamentally about the movement of money. And that in and of itself is a heavily regulated area because you have to think about anti-money laundering and anti-terrorism concerns. So you have KYC, KYB. You have to think about, are you a money service business? Do you need to register as such? What about money transmission licensing? Is the flow of funds as you have structured it one that makes you susceptible to having to seek that licensure? If so, do you maybe want to think about a different flow of funds so that you don't have to look for money transmission licensure in 49 different states? But that's so inherent to payments that you can't really get away from the fact that when you're moving money, you have to think about all of the regulations inherent in moving money.
Yeah, that makes sense. I find also that one of the most confusing things is there's not one set of rules, right? You've got
Right.
the card brands, you've got payment networks like the ACH network and now RTP, you've got the overlay of AML. There's a lot of different regulators that, as you said before, sometimes have conflicting laws or advice. And so it's unlike other, I think, forms where it's like, here's the rule book, go study it. And once you're done, you'll know everything. It's kind of an expansive universe.
Absolutely. Yeah.
When you work with software platforms or ISVs, what's one of the most common misconceptions that you encounter?
It was really hard to narrow this one down. Again, we were limited to one each. We decided it would be one
Okay.
each. You said one of the most common misconceptions, but we couldn't decide among ourselves with just one. So the one that I picked was the misconception, especially among new entrants, is that there is some kind of standardized process for how everybody works, and they're just going to slot into the standard, when in fact that is not the case. You have to ask all the questions about how will the money flow for you? What is your expectation for how payments will be made or shared? Where are you expecting the money to go? Who will hold title to it? You have to ask all of the questions and not make assumptions about there being some overarching standardized process that's just going to flow seamlessly, because there isn't one necessarily. There is lots of room to innovate.
Yeah. And mine was that the misconception is that merchants and all the data about their transactions belong to you as the platform, as a right that can't be contracted away. And I think that is the frustration that many platforms run into, is they sign up with a payments provider because the commercials are good and they like certain functionality, and not realizing that once you've given the merchants over to the payments provider, they now belong to the payments provider and you can't take them away, and soliciting them would be a breach of your contract. Or if you do take them away, that the data comes with them. Those are all points that you can make that the legal reality, but it's through the contracting process. It's not just a right you have.
Makes sense. Leave it to the lawyers to pick apart that you each get one versus one. I love it. I love it. No, those are great misconceptions. Let's keep moving, because I want to cover some topics like emerging categories and underwriting novel areas like nutraceuticals. It's always a challenge. We get asked all the time, can you do nutraceuticals? There's many other of these emerging verticals. What are you seeing right now with regard to emerging categories? Why are they so difficult to underwrite? And what do you think software platforms need to consider before they board merchants in these types of categories?
Well, I'm afraid our answer might be a little anticlimactic in some ways. So obviously changes in federal law. We know just recently there's this new federal law specifically about CBD, changing the concentrations that can be legally marketed. So the fact that the law is constantly changing obviously makes underwriting something of a moving target, right? Because what was legal today may not be legal tomorrow. And so your underwriting has to adapt to that. Getting new products on the market like GLP-1s and peptides, which are, the new shiny toy, and everybody wants to be able to sell those, become an area ripe for abuse, right? Because there can be counterfeits. But in terms of what do you need to do to protect yourself or to have strong underwriting, in some ways, it's nothing new, because we see the same old frauds and the same old tricks that bad actors use redeployed with a shiny new wrapper. So it's not necessarily that there is anything new or innovative about the way bad actors are trying to exploit the new verticals or the new products. It's just the same old tricks with a new package on them. So if you have really good, experienced underwriting and risk monitoring professionals, they will be able to spot the tricks of the trade used by fraudsters. And I think the biggest issue is really just being able to stay abreast of the changes in law and changes in regulation. But that's nothing new. That is always the case, and that's always a challenge.
And I think in terms of consequences, you know, participating in the payments ecosystem is a privilege, not a right. So that you can lose your ability to accept cards as a form of payment, which is catastrophic in today's economy. And the other one is that regulators are increasingly aware, I'd say really over the past 10 years, maybe the early 20 teens, that the payments industry even exists. But when they found out that we exist, they realize it's a great place to apply pressure. And the pressure that they can exert over a payments company or a platform is pretty profound, especially because oftentimes they're looking at least from a monetary perspective, what's the entire amount of harm caused to consumers, and they'll measure that as total transaction volume minus only chargebacks and refunds. And you're as a payments company or a platform.
So it's a big number.
It's a huge number, and
Really big number.
you're getting basis points or small percentages, but your exposure is many, many times that. And so that's something to always keep in mind is even when margin is great on a high risk merchant, be careful because your exposure luck could be vastly more than your best day in terms of profitability.
That's right. If software platforms want to work with these type of riskier merchants, what would you advise them to tell their payment provider, and how upfront should they be?
Transparency is key. And you want to make sure that your payments provider knows what you're doing, knows what type of transactions you're submitting. If you don't, and they're surprised, they can require you to exit a vertical completely or even terminate your account, which causes huge reputational injury. You'll probably never get those merchants back. The whole vertical may be beyond your reach at that point. So surprising them is not a good idea. And number two, I think you can expect rigor when you go to a payments provider, and a good one, and you say, hey, look, I want to support this high risk vertical. They're going to ask a lot of questions. They're going to pressure test your entry into that market. And you should really see that as a blessing and not a burden, because what they're helping you do is they're helping you vet the compliance with their own questions. And so that hopefully at the end of the day, you come up with a defensible approach to that market, which may be very profitable. You may have great margins, but you're not engaging in the practices that regulators would view as the low-hanging fruit for enforcement activity.
Yeah, that's something we do a lot at Rainforest. Our risk team tends to be very collaborative with our software platforms to figure out how can we get to a yes. And I think there's a lot of, maybe less scrupulous providers out there that we've seen that don't do that. They may not have that rigor. And what I think listeners need to remember is that there's a whole food chain above that payment provider, and in the best case, it's just the sponsor bank and the card networks. And worst case, they could be a reseller of a reseller of a reseller. And so there's several other people that may kind of come in and shut that down and have way less empathy than the payments provider who's ultimately working directly with the client, as opposed to the card networks who are 5 steps removed and it's just a row in Excel of a problem to fix and basically kick off the platform. So I think that's a huge difference that we've seen in kind of the DNA of payments companies and how different people treat it.
Yeah.
I want to talk a little bit now about the regulatory side of things. Let's start first on the state side. I think we've all seen an uptick in state level rules like click to cancel requirements, honest pricing, and air quotes laws. What's driving this wave of new regulations, specifically at the state level?
It's a good question. I think there are two things. First is that there's a vacuum at the federal level, and the federal level of regulation, I kind of think of as a giant fire blanket because of the supremacy clause. If there's a fire raging at the state level, if you have a federal regulation, you toss it over the states. It puts out the state fires because federal law reigns supreme and the states cannot legislate in contravention of it. They could maybe legislate something extra, but they can't legislate in contravention of it. But we don't have a federal rule that mandates honest pricing or a click to cancel rule. We only have small slivers of that have made it past the finish line. The FTC tried to have a click to cancel rule. It did not make it past the finish line in its full form. It tried to have honest pricing. Like none of these things really took. And so the states have responded by enacting their own. And this is where we have the second set of factors driving it. And I think it's a push and pull between two groups that they get a lot of press. We have the merchants on one hand, which are saying we want to defray the costs of accepting cards. It's very expensive for us. We want to pass this on like we'd pass on anything, right? Like cost of goods sold. And then we have the consumer saying we don't want to have to pay for the cost of card acceptance. It's unfair that this all gets crammed down on us. And so we have the merchants on one hand bringing class actions, for example, like the multi-district litigation against Visa and MasterCard that's been going on for multiple decades now, where they're saying it's too expensive to accept cards. It shouldn't be this expensive. And then we have states reacting, saying we're going to protect consumers and make it so that they don't have to pay all of these additional costs that the merchants are trying to push down on them. So there's constant tension between merchants and consumers, and the state laws and regulations are reactions to that, where the federal government has not put anything in place. So we get click to cancel and we get honest pricing laws so that they're not necessarily saying that the merchants cannot pass costs down, but the thrust of these laws is these costs cannot be passed down in a way that is perceived as unfair or deceptive or surprising to consumers. If you want to pass the costs down, they have to be passed down in a way that's transparent. And if you want to exit that business relationship. It has to be easy for the consumer. And that's the thrust of most of these laws.
Got it. Let's shift to the federal level then. And you touched on it a little bit, but specifically with the FTC, the FPB, you kind of listed all the things that they haven't done and haven't gotten across the finish line. Are there some things that they have gotten across the finish line that we need to be thinking about?
Yes, and it's enforcement actions. Unfortunately, it's really interesting talking with our counterparts in the EU or even the UK. We talk about like, well, what are regulators like? And it seems very collaborative. And they come up with a rule set, and you negotiate about what the rules will be, or provide your input, and then you have the rules and you follow the rules. In the US, we really don't know what the rules are. What you know is that you need to watch what the CFPB and the FTC are doing. Because their enforcement actions and the complaints they lay out, and then the stipulated orders they get in place after an enforcement action, shows you what they're concerned about, what they perceive as red flags in the industry, and then how they think you should be remediating it, which is oftentimes how they view how a payments company or a platform should be doing underwriting and risk monitoring. And if you want to look at examples of cases where it's gone wrong, I think if you do a Google search for FTC and Revenue Wire or Blue Snap or more recently Paddle, what you'll see is, number one, the Federal Trade Commission in particular really understands payments. They understand it very well. They understand the card brand rules. They will pursue enforcement actions against platforms that are playing fast and loose with card brand rules, which actually can have legal interplay, especially under the telemarketing sales rule. And they'll use ROSCA, which is a law that it was really meant to protect online shoppers, but they've used it in a very innovative ways to go after platforms and payments providers that are supporting merchants who are engaged in advertising they don't like. So it's really important to pay attention to each case that comes down. What did the FTC or the CFPB not like about it? CFPB being less pertinent today than it was 4 years ago. And then look at the stipulated order and see what do they think the payments company or the platform should have been doing to do it right, and then use that to educate yourself about tweaks to make to your own underwriting or risk monitoring departments.
One more federal piece I wanted to touch on is FIRREA, which I had to look up the acronym, what it stood for, but it's the Financial Institutions Reform, Recovery, and Enforcement Act, back from 1989. So this is an old act on the book, but talk to us a little bit about how does this come into play today here in coming into 2026 with payments risk, fraud, underwriting failures?
Great question. And it's becoming more pertinent, I think, by the day. So FIRREA, as you pointed out, was passed in 89 in light of the savings and loan crisis of the 1980s. And what it basically did is say if you engage in bad activity that affects a federally insured financial institution, then you can be liable for a FIRREA violation. And for our purposes, the bad things you could be doing that could affect a bank that you want to be aware of, it's wire fraud and mail fraud. So sending something untrue or inaccurate or potentially deceptive through email, through telephone lines, whatever the case might be, or in post, which I think is less
relevant today, probably, right?
Yeah. I'm not sure you're mailing your receipts from the chunk machine like you did in the olden days. It's probably less real. I actually have a chunk machine in my office. But I think where it comes into play for these companies these days is you've had federal regulators expand what FIRREA means, probably well beyond what the legislators intended when they passed it. And now it can be used to attack things like inaccurate statements in merchant applications. So if you have an untoward referral agent who says, look, I know you're running this nutraceutical company. We don't want you to have one merchant account that could be shut down when the chargebacks get too high. Let's set up 20 with your friends and family posing as CEOs for ostensibly separate LLCs. Or let's take you're selling CBD back when it was more risque, and we'll say you're selling cooking oil instead of hemp
CBD oil. Yeah.
But as soon as you put that in a merchant application and send it to a bank, well, now you've affected a financial institution and you can be liable for a FIRREA violation. Same thing. We've at least heard rumors of the same thing happening with respect to data elements submitted along with the transaction to get better interchange qualification. Is that potentially a FIRREA violation? And the thing that's so scary about FIRREA, number one, its per violation penalty is $1 million. For a continuing violation, it's $5 million, but a court can go as high as the entire amount within the statute of limitations that a defendant received from its allegedly bad act. And it goes back 10-year statute of limitations. So if you think about, a merchant acquirer or a platform who engages in something just on the margins of shady that affected a bank, and they had some financial benefit, even if it's not huge on a per transaction or per merchant level, aggregated over 10 years, that can be really punishing. And so it's certainly a statute to be aware of and to stay far away from if at all possible.
So what I'm hearing is there's a really complex web of federal and state laws that people need to be careful about. We really need to do the right thing. Let's talk specifically, though, about software platforms. What role do you think they play in complying with these regulations? And I'm kind of thinking impact to their product when they're thinking about checkout pages, subscription management, those type of things.
It's an interesting question because obviously there's all of the regulations that probably get pushed down from the level of the sponsorship agreement that you're going to have with the bank for things like AML, KYC screening. But when you're talking about checkout pages, subscription management, all of that sort of thing, the things that are more end user facing, the level of compliance is primarily a product decision. And there are some, especially with new entrants in the space, that really struggle with this, who say, we don't want to help with compliance. We don't want to help merchants with compliance. We are just providing essentially back-end connectivity, and it's the merchant's responsibility to understand their own business and to be compliant with whatever laws govern them, all the way to the other end of the spectrum where platforms want to provide essentially like that end-to-end compliance solution, which is a very heavy burden because you have to be so familiar with all of your merchants' business, and those end up
Right.
really being more pigeonholed to a particular industry because you can't be an expert in everything. And we find that it really affects, obviously, the price of your service offering if you're doing that, the liability you're willing to take on, and it makes for vastly different product offerings. But this goes back to one of the misconceptions at the beginning that I think merchants have a lot, is the idea that there's some kind of standardization. Like if I get a platform, they're going to help me with X, or I've outsourced this. Not necessarily, because the issue of compliance is a service offering like any other, and it varies widely. Some people are willing to do that, some people aren't. And merchants have, I think, a lot of confusion about exactly what level of service offering they're getting with a platform.
Yeah, we hear that a lot from prospects. They may come to us and say, processor ABC is letting us do it this way. Will you also let us do it the same way? And sometimes we have to come back and say, unfortunately, we can't. I can't talk to what that other provider is doing. But clearly this is in violation of card brand rules or some other statute. And so it's kind of interesting that everyone interprets these a little differently. And this kind of, I think the level of depth that various payment providers go into and looking at these things varies widely. And so we've all, I think, can agree we've seen some kind of crazy stuff out there, but there is an expectation of, well, this bank did it or this processor did it, why won't you? Which is always a challenging conversation.
Yes, the conflating of permission to do it with a stamp of approval that is compliance happens a lot. And in reality, I think there are some providers who are saying we refuse to opine, we're allowing it to happen, but whether it's compliant or not is not our problem. Probably is their problem, but they choose not to wade into
Yeah.
the fire.
The merchants feel like they're getting, have the protection of the platform, but all the platform is going to do when the card brands assess a fine is seek indemnification and pass that fine along on to you.
Right.
So they got the margin from your transactions, and now they're fully protected from the financial consequence. Not great. And as you were talking, Joshua, all I was hearing or was thinking about was the surcharging conversations we had 5 or 6 years ago when we're like, well, this is not a compliant solution. Well, everyone's doing it. I went to the Mexican restaurant down the street and they did it. So it must be okay. And that was the prevailing wisdom, is what everyone else is doing, it's fine. And I think with anyone in the payments industry over the past 2 or 3 years knows that non-compliant surcharging is definitely not fine, and the consequences can be pretty dire.
I want to cover one last legal topic before we move on to just some last general advice, and that's class action lawsuits. I know you both have seen this play out over the decades that you've been working in payments. I think a lot of people may be surprised to hear that both software companies and payment providers can get hit with class action lawsuits. What are some examples that SaaS operators should be aware of as they're thinking about their product design and which payment partner they choose to work with?
Sure. And so I think Theresa and I will break this up and take it in 2 parts. So I can focus on more of the traditional merchant acquirer class action. We have seen before 2015, no plaintiff's class action firm knew what a payment processor was. We were completely invisible. I mean, yes, they knew about Visa and MasterCard. They went after them, but payments was relatively safe because it was unknown. And when they discovered us, all it takes is one. They discovered the payments industry. I think the first case was actually brought here in Georgia. There were 2 cases brought here in Georgia against the payments platform, and it was everyone in the chain. So you can get the ISO, the processor. It could be a platform that also gets named along with it because they're looking for as many deep pockets as they can reach their hands into. We're not plaintiffs class action lawyers if that's not painfully clear by this
Sure.
point. They cast a very wide net of anyone involved in the process where something unfair was done to either a merchant or even a consumer. And where we have seen most of those class actions gravitate towards are challenges to fees and fee amendments. And so most frequently from the very beginning, it was you're being dishonest about cost plus pricing. You're saying it's interchange plus, it's not, or you're putting other things in interchange before you pass it along to the merchant. And then you've seen a rash of cases since then. I think we're now on about the 20th merchant class action against platforms and processors where they've said you amended this fee and you didn't technically follow the roadmap your merchant agreement laid out for amending the fee or your end user license agreement if you're the platform. You didn't follow those rules exactly. And therefore, every dollar you've collected in that fee over the past 6, 7, 11 years, depending on the state, is a breach of contract for which we're entitled to damages. And those are not, they're far too lucrative for the plaintiff's bar to go away anytime soon. But Theresa, I think you had more to add on that as well.
I think you've covered probably the most relevant ones, but it's worth noting that there are some class operators that are sort of incident to payments that have also gotten dragged into merchant class actions. For example, customer relationship management databases and
Interesting.
mitigation companies that end up integrating with payment platforms have themselves been named as defendants in class actions on the theory that, for example, you promised to help us do what is effectively called load balancing. And that was a bad thing. And we shouldn't have been doing that. And we got in a lot of trouble. And we only did it because of you. It's a very shorthand, inelegant way of saying it. But those sorts of theories have been brought forward by groups of merchants in class actions. And that ends up being very long litigation. But there are a number of different ways that merchants have come at the various players that sort of stack up and integrate together through APIs, all for the purpose of being able to pursue their business and accept payments.
As we move into closing, I'd love to hear from each of you. If you could give vertical SaaS leaders just one piece of advice about staying on the right side of payments law, what would it be?
Okay, we did the lawyer thing again, and we combined two poems.
Okay, got it.
One piece of advice that breaks down
Just
into
one.
3 subparts. Okay.
Yeah. So it starts with the golden rule, which is to treat your merchants fairly.
But
Because we're lawyers, there's a but.
don't be afraid to make the hard decisions about a bad merchant that might not be performing according to your expectations or your policies, even if it's a lucrative merchant for you.
And then there's an asterisk because we are lawyers. We have the disjunctive, and then we have a footnote that goes along
Love
with
it.
which is when you feel like you need to ask questions, when you're in that really tough circumstance, take advantage of attorney-client privilege. If you have an in-house lawyer, ask them questions. Hopefully they have payments experience. You may have outside counsel you can ask, but that asking questions is key throughout the process to protect yourself. Asking questions from your risk team, from your underwriting team, even from the sales guys, asking questions to the merchant is all important. But all those conversations, you have to understand if things get nasty and there's litigation, all those conversations are discoverable, which means the other side gets to see them. If you have a lawyer and you want to go through some really tough questions about a merchant, those conversations stay behind the cloak of privilege. You can be completely candid and honest, get the feedback you want, and adjust it. That's our one rule.
Very good. Very good. I think that was like 2 or 3 all put together, but that is, I think, really solid advice. Well, thank you so much both for being on the show. Super informative. We covered a lot of ground between the federal side of things, the state side, class actions, practical advice. So thank you both so much for your time. If people want to get in contact with you, what is the best way to do that?
Well, thank you for having us, first of all. And then you can email either one of us at or you can find us online at agg.com. You can look up our professional bios there, or shoot us an email. I'm at edward.marshall@agg.com. And Theresa's at teresa.kananen, Kananen, at agg.com.
One day I aspire to have a last name that does not require spelling.
There you go. Thanks so much for being with us. We appreciate it.
All right.
Thanks,
Thank you
Joshua.
for having us.